This isn't your typical quiet morning in court. We've got phone calls, secret recordings, and possible witness tampering allegations on the table. The case centers on Mr. Lee, a defendant accused of trying to strike a side deal with a victim in his case, Mr. Kwasny. The alleged offer? If Kwasny doesn't testify against Lee, Lee won't testify against Kwasny in a separate case. The prosecution says they've got a recording to back it up, a recording that just hit the courtroom this morning. The defense hasn't even had time to fully review it. And right from the start, the judge is circling one very serious word: interference. What's at stake? Potential new charges and even a bond revocation. But before we jump to conclusions, keep your ears open, because as you're about to hear, Mr. Lee thinks this was all just part of plea negotiations. Is this a clever legal strategy gone wrong, or a desperate move that crossed the line?
That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Thoroughly.
What is that noise?
Right. Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop at some.
It'll stop at some point.
I feel very safe, Your Honor.
Oh, I know. He's like, you are all over it. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Kwasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange of a pending case where Mr. Kwasny is the defendant of an AMB against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Kwasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Kwasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want to document the potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But
This is the moment the stakes spike. The court hears that Mr. Lee allegedly reached out directly to the victim's attorney, offering a mutual silence pact. In plain language, you stay quiet in my case, I'll stay quiet in yours. From a legal standpoint, this is highly dangerous territory. In most jurisdictions, any attempt to influence a witness's decision to testify, even indirectly, can be considered obstruction or witness tampering. It doesn't matter if the defendant believes it's a mutually beneficial agreement. The law sees it as interfering with the justice process. Here's the question for you. Is this a clear-cut example of witness tampering or just a poorly handled attempt at a plea discussion?
I can't agree to that characterization because I haven't heard it. I don't know.
well, you want to listen to because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge. I
indicated to, what's her name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement.
Now, Lee takes the floor, and his argument pivots sharply. He claims he only made the call because his own attorney, Mr. Burgess, failed to pursue plea negotiations like he'd instructed. Lee says he recorded the call to prove Burgess was ineffective, even referencing Strickland versus Washington, the landmark case on ineffective counsel. This is a fascinating moment. Lee is essentially building a record for a potential motion to remove his attorney, while simultaneously defending himself against a possible new charge. The problem? The prosecution has a very different version of what's on that recording, and they say it's crystal clear Lee was proposing a no-testimony deal. So the tension here isn't just legal, it's personal. This is turning into a case where the defendant is fighting both the prosecution and his own lawyer.
So now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the call. I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Kwasny agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone.
And here's where the tone shifts from tense to explosive. The judge has heard enough to be extremely disturbing and openly considers revoking Lee's bond, meaning he could be taken into custody immediately. The tipping point? The possibility that Lee has actively interfered with the integrity of the case. When a judge uses language like revoking bond, that's not just a procedural warning. It's a signal that they see a serious breach of trust. Bond is a privilege, not a right, and it rests on the understanding that the defendant will not commit new offenses or obstruct justice while out. This is a make-or-break moment. Once bond is revoked, the leverage shifts dramatically to the prosecution, and the defendant's ability to prepare for trial is severely hampered.
You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right.
Okay.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that, Your
And
Honor.
so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
By the end, the judge hasn't made a final ruling on the bond yet, but the message is clear. If the prosecution's version of that recording holds up, Lee could be facing far more than the original charges. We're talking about potential witness tampering, a charge that carries heavy penalties and can seriously damage credibility with any future jury. The big takeaway? In the justice system, even the appearance of interfering with witnesses is dangerous. Conversations that might seem harmless in private can become legal landmines in court. If you found this case as intense and jaw-dropping as we did, make sure to hit that like button, share your thoughts in the comments. Do you think this was tampering or just a negotiation gone wrong? And subscribe for more real-life courtroom breakdowns.